Professor Campbell, I noticed in your discussion of the Interstate Commerce Clause how quickly the discussion of the power of Congress to regulate interstate commerce became a discussion of the power to regulate what affects interstate commerce, which is not what the clause says. My question is, since both slavery and alcohol distribution were in interstate commerce, why is it that the country believed it needed to amend the Constitution to outlaw those things, but outlaws drugs simply by an act of Congress?
Well, the modern interpretation of the Commerce Clause says that Congress, under the Commerce Clause, has three types of powers. The first pertains to instrumentalities of interstate commerce. So that would be things like, for example, the internet or telephones or, large systems that are interstate that we use in our everyday lives and in our business. So when it comes to criminal law, for example, there are a number of criminal laws that regulate criminal conduct based on the use of these interstate commerce facilities. So fraud is a state crime, but wire fraud and mail fraud are federal crimes. Second, the channels of interstate commerce, and this is all by decision of the Supreme Court. The channels of interstate commerce would include things like roads, bridges, etc. And so there are times when simple travel in interstate commerce, for example, a state border crossing, will be enough to create the power of Congress to regulate. And I'm talking about criminal law now, which is my field. And then finally, any activity that substantially affects interstate commerce is viewed as subject to federal regulation. Again, this is a case, I believe, from about 1995, in which the court was interpreting what types of activities would fall under the commerce power. So the interpretation of these various clauses does change over time. And the modern court, and when I say the modern court, I mean the court of the last 20 or 30 years, post the Warren Court, which is a much more conservative court, has attempted to rein in Congress's Commerce Clause jurisdiction. So these three categories that were set out in United States v. Lopez are actually an attempt to give some shape to Commerce Clause jurisdiction and to say it can't just be anything. It has to either be interstate commerce facilities, the channels of commerce, or something that substantially affects commerce. So that is what the modern Commerce Clause interpretation is.
Let me just add, with respect to your specific question about slavery and alcohol, I think at the time that slavery was an issue, one of the problems would be that there are at least 9 provisions in the Constitution that deal directly with slavery, though the word is never used. So I think there would have been a considerable difficulty in using the legislative power at that time to have outlawed slavery. With respect to alcohol, I think the difference there is that at the time that alcohol prohibition was an issue in the United States, nobody thought that Congress had the power in interstate commerce to regulate intrastate activities that simply had an effect on interstate commerce. They would have had to have had an effect that was quite considerable. And the consumption of alcohol is more or less a local matter. It has an effect on interstate commerce, but I think the conception of the commerce power at that time was quite different than it became post-1937. So it's probably an historical explanation, really, for those two.
Yes, ma'am.
Well, I remember the time for...
You can talk a little louder and then
okay.
make sure you can be here
well, I'm wondering about the Supreme Court decision that ruled against California in 2005. And just as a casual observer of the situation, I remember thinking, okay, that's the end of that. And the next thing you know, we start hearing about states legalizing marijuana in various ways, and I just wondered, how did that happen? I mean, they just can make a law that is not legal?
Well, again, they have the right to make whatever laws they want. But citizens in those states are also subject to federal laws, so they have to decide whether they're going to violate federal law when they can still be prosecuted by federal authorities. Part of what's happened with marijuana is that the Obama administration took a public position early on that they would not prosecute individuals who were compliant with their local medical marijuana statutes because they felt, as sort of for humanitarian reasons, given that most medical marijuana statutes are fairly limited, that it would be wrong to prosecute a cancer patient who had a valid prescription and was complying with local medical marijuana laws, and they were quite public about taking that position. However, what happened was that, in particular in California, the medical marijuana statute was being used as sort of a sub rosa way to legalize marijuana, and both the definitions were very loose and the enforcement was very loose, so that you would have dispensaries that were selling beyond what was allowed by California law. And then the federal authorities did come in and begin prosecuting. This created a fair amount of conflict. The defendants would claim, well, we were complying with local law and you said that was okay. And the feds basically said you weren't complying with local law and this is our policy. So it's continued to be controversial. The Obama administration has not yet publicly taken a position on these legalization statutes, and it'll be interesting to see what they decide to do. Of course, one thing that would be possible would be for Congress to change federal law and decide to legalize marijuana at the federal level, which would take away the conflict. Right now, Gallup shows about 50% of the public supports legalization, but the question is asked in a very basic way. And I think what a lot of people probably support is they don't want to see people locked up for just having one joint or something, but they might not go so far as saying, yes, complete legalization, dispensaries on, every corner type of thing. And I think it's unlikely, in my estimation, that Congress is going to go ahead and legalize marijuana anytime soon. So I do think that this conflict is going to bubble up over the next 5 or 10 years, and it'll have to be the subject of public dialogue, and we'll have to see how it all shakes out. It's very interesting.
Do you think New Hampshire should sell marijuana from its northbound or southbound store off of Route 93?
I have a follow-up to Amy's question to Professor Campbell. What do you think the impact will be, considering that federal authorities don't enforce possession statutes generally, which is a misdemeanor under federal law, personal use of marijuana? I mean, do you think that the federal authorities are going to now expand resources to fill the vacuum that would exist within these two states? And then I guess another question to that is, what's the impact or interaction between trafficking, which would still be against both state and federal law there, and allowing the personal use or possession?
Well, yes, that's exactly right. And as I mentioned earlier, when I used to do intake in the Eastern District of New York, we had quantity limitations, and our limitation for marijuana was 1 ton. And below 1 ton, we did not prosecute. And to answer your question, I don't think that we're going to see DEA locking up people for having a joint, but I do think we'll see them going after large-scale growers and distributors, because that would conflict with federal law.
Just a point of information, that may be the case in the Eastern District of New York, but in the District of New Hampshire, small quantities of drugs are prosecuted in federal court routinely.
Well, yes. I mean, in Vermont, I think it's 30 pounds or above. So it's a much lower amount, but it's not a joint. I mean, I've never seen, I don't think there are any people in federal prison for true personal use quantities of drugs, but there are for smaller scale trafficking charges.
Sir.
It may not provoke as much deep thought as marijuana, but I wonder if Professor Massey might comment on the interplay of Interstate Commerce Clause and 9th and 10th Amendments on proposals now to either prohibit or authorize taxation of internet by a state and local government.
Well, the internet's an instrumentality of interstate commerce. So I don't think there's a lot of dispute over congressional power to to regulate that instrumentality, subject to other constitutional limitations. So if Congress chooses to impose a uniform rule with respect to requiring providers of goods and services over the internet to collect sales taxes applicable to the state in which the product or service is to be delivered, I think that's entirely constitutional. That's, I mean, I don't think there's any doubt that that's an instrumentality of interstate commerce, and I don't see the likelihood that the court's going to revisit that dimension of the Commerce Clause.
What about the other side, though, of Congress prohibiting states from levying taxes?
I think it has the power to do that as well. Again, it's an instrumentality of interstate commerce, and Congress has done something similar. For example, a few years ago, it enacted a statute that prohibits states from imposing state income taxes on pensions that are derived from years of work within a state that imposes the income tax. So, quite personally, for example, I am due a pension from the University of California. Now, as a resident of New Hampshire, I am blissfully free of onerous California income taxes, thanks to Congress.
Can I actually just follow up on that? Because I've looked a bit at the Internet as a facility of interstate commerce, because it's coming up quite a bit now in federal criminal law. Specifically in the state of Vermont, there was quite a high-profile kidnapping and murder of a young girl by a sex offender, in which the federal authorities took jurisdiction over the case because the Internet was used in the kidnapping and are now seeking the death penalty, which is not permitted in Vermont. So I've looked at the issues around that. And in connection with that, it's quite clear, and as I'm sure Professor Massey was referring to, that many federal courts have held that the Internet is a facility of interstate commerce, and some have also held that the Dormant Commerce Clause prohibits state regulation of the Internet. So I'm sure that's sort of what you were referring to, but I think it has been held, expressly by federal courts that the states can't have separate regulations of the Internet for that reason.
And that phrase, Dormant Commerce Clause, there's no separate Commerce Clause. It's a negative inference we draw from the Commerce Clause that states cannot interfere with interstate commerce, especially in a way that impacts out-of-state residents who have no say in the state's political process. So that's a separate constitutional Commerce Clause doctrine. Bill.
This is for Professor Nakanoff. Starting from the proposition of one person, one vote, which is a constitutional rule, as I understand it, have you and your colleagues that study election law tried to use that as some way to build an argument to limit campaign spending?
Wow.
Just add one other footnote. It would seem to me, the court in Citizens United made very clear that the First Amendment is not interested in a fair, level playing field. But I wonder if you start from one person, one vote, which is a fair and level playing field, whether you could get to a different result.
My sense is the court is not likely to read the Reynolds versus Sims standard, the Baker, then Reynolds, one person, one vote, to go in this direction, since it's not exactly the vote. The First Amendment issue, we like to think about the problem of what about the noisy sound truck in the marketplace of ideas? Is there any kind of a right for voices that can't project over the noisy sound truck to be heard? And the court has said no. It wouldn't be my preferred outcome, but they see, as long as we believe that money is speech, it's going to be very hard to get around that. They have not overturned Buckley, where there's a distinction between contributions and expenditures, but corporate speech now is treated as equal with individual speech, and that's going to make for some noisy sound trucks until and unless Congress decides on some other kind of response that might pass constitutional muster under Citizens United.
Sir, yes.
This is for Calvin Massey. I'm very curious. So is one of your guiding principles here that, so the Federalists didn't think, basically, and James Madison in particular, didn't think, for the most part, that the Bill of Rights was necessary. Because the system of government set up was built on diversity of factions and multiple factions, and even without the Bill of Rights, minority rights would be protected through the mechanism of faction facing off against faction. But your argument for the significance of the 9th and 10th Amendment is in a nutshell, an argument that Madison was wrong on the federal level, right? Because majority faction could form. You could have, the federal government, the federal legislature could be a danger to liberty, which I think, I would want to say that Madison thought that was remote. But you're suggesting a solution to the potential of a majority faction terrorizing the minority at the federal legislative level, correct? So I guess my question, and I'm getting past my 30 seconds, my question is, so where you're coming from, is that based on a assertion about a flaw in that Federalist concept?
No, I don't think it's based on a belief that there's a flaw in it. I think James Madison, along with all of the other framers, would have thought that the principal mechanism for protecting liberties would be found in state constitutions. Yeah, and indeed that was the way that the Bill of Rights was interpreted up until the end of the Civil War and the adoption of the 14th Amendment. The protection against federal overreaching was, I think, thought by Madison and others to be in the reversal of the usual presumption, so that the federal government only had these limited enumerated powers. And therein lies the rub. What's the scope of those powers? Madison himself was involved in a great deal of correspondence pertaining to the adoption of the 9th Amendment. And he seemed to be aware of both aspects of the 9th Amendment, both as a device to caution against the notion that this was an exhaustive list of the rights of the people, most dramatically expressed by Representative Theodore Sedgwick from Massachusetts, who on the floor of the House said, well, you give me this, whatever list of rights you give me, I can always add more to that list, whether to wear a hat or not, what time to go to bed, what time to rise. And so he vividly portrayed that aspect of it. But Madison was also aware that there was a danger in any enumeration that would carry with it the implication that the federal government had implied powers. So, Madison may have thought that there are lots of other mechanisms that would prevent federal overreaching, but he was an adaptive man. If it was a flaw, he recognized it and was quite willing, and indeed one of the proponents and architects of the 9th Amendment.